Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, we have a great show for you today. First, more secrecy in the Bryan Kohberger matter and why the defense is focusing on the penalty phase. Lori Vallow, the prosecution has rested, and, well, so will Lori. Karen Reed is giving pretrial interviews, but something I've never seen before. We have This Day in Legal History and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, I'm going to remind you to go to crimetalksearch.com, where you can sign up for a background subscription service. Now, the beautiful thing is when you have the subscription, which you can cancel at any time, you can do as many background searches as you desire. And you're going to be able to get all types of information about the person you are searching. For example, you'll be able to find out phone numbers associated with that person. You're going to be able to find out if they have emails, all of them, all of the emails, ladies and gentlemen. You're going to find out if they own property, if they have criminal history. Are they married? Are they divorced? Are they on one of those sex offender registries? Yes, go check it out. Whether this person is new coming into your life, maybe it's the parents of the children that are coming into your life through your kids' friends, go check them out. Go to crimetalksearch.com. You'll be happy you did. All right, let's go ahead and open the record for Thursday, April 17th, 2025. First on the docket, more secrecy and more orders coming out in the Bryan Kohberger matter. The first order is the order regarding the motion in limine in regards to family members remaining in the courtroom. As you may recall, at the motions hearing a couple of weeks ago, the prosecution is going to endorse Bryan Kohberger's family. The defense wants Mr. Kohberger's family to be able to be there and to be able to support him. And it shows that he has somebody in his life, right, when they're making that argument for life and not death. So the court issues an order here. The state requests an order pursuant to Article 1, Section 22 of the Idaho Constitution, as well as the Idaho Code, Section 19-5306, 1B and 3, allowing immediate family members of the homicide's victims to be present during the entire trial, regardless of whether they are scheduled to testify. Attached to the state's motion is Exhibit S1. A list of those individuals that the state considers to be immediate families under the foregoing provisions. They are the siblings, parents, grandparents, and step-parents of the deceased, and the defendant stipulates that the individuals listed in S1 may remain in the courtroom during the trial, but asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed as coercive to the jury. That's always those shirts, ladies and gentlemen. Going to court tip 101. If somebody ever dies in your family, please do not show up with the embossed silk screen of the person's face on a t-shirt. Tacky, should never be done. It helps in no particular way. Okay? Just keep it at that. Now, I'm not saying anyone was going to do that in this particular case, but no, don't do the shirt thing. Okay? No. Anyway, the state agrees that the court has the discretion to issue orders regarding courtroom decorum, and at the appropriate time, the court will exercise its discretion in this regard. However, in his response to the state's motion, the defendant requests that his immediate family members, siblings, and parents be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on the grounds that while family members of homicide victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family members. The state also contends that it intends to call members of defendant's family as witnesses at trial and will ask the court to exclude any testifying witness from the courtroom pursuant to the Idaho Rules of Evidence, Rule 615. The United States Supreme Court has recognized the right of a public trial afforded by the Sixth Amendment entitles a criminal defendant, at the very least, to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family member present at trial advances the values served by the right to a public trial. ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to a public trial is not absolute. The right to an open trial may give way in certain cases to other rights or interests. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of the trial, is permitted if there is an overriding interest for the closure of the narrowly tailored to serve the interest. Here, the purpose for the closure requested by the state is Idaho Rules of Evidence 615, which provides in relevant part that at a party's request, the court may order witnesses excluded so that they cannot hear the other witness's testimony. That's commonly referred to as a sequestration order. This is a discretionary decision. Idaho law, and the judge cites a case, State v. Danson. Now, while the court is sensitive to the state's concerns about allowing testifying witnesses present during the trial, the court is also sensitive to the fact that this is anticipated to be a lengthy trial and that the defendant would like the support of his family. Further, the scope of his family member's testimony is likely going to be limited, and in an effort to reach a solution that upholds the rights of both parties, the court will require the state to submit for an ex parte, in-camera review a list of the Kohberger family members the state intends to call at trial and for the purpose of calling each of those witnesses. The state must also identify why each family member cannot be called very early in its case in chief and articulate why exclusions of the family members is necessary under the exclusionary rule, particularly given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Kohberger family witnesses. The state must submit these materials no later than April 25th, 2025. The court will provide the parties with this decision at or before the pretrial conference on May 15th, 2025. And for now, the motion is granted as the homicide's victim's family and reserved as to defendant's family. So, interesting issue. This came up at the pretrial hearing. Obviously, family members of the victims have a right under the Idaho Constitution to remain in the courtroom, even if they're going to testify. Now, frankly, the victims' family members would have limited testimony, if at all. I can't even think of anything as of right now why they would actually have to testify. Maybe as to identification, that would be it, as to their children, but there's other ways of doing that. The defense gets a little trickier, and the prosecution said, hey, the family is on our witness list. They're going to be endorsed, and under the sequestration order, under Rule 615, Judge, they should not be allowed to sit in the courtroom unless and until they have been excused from their subpoena or they've testified and excused from their subpoenas at that point. And the judge is saying, come on, man. Come on, state. Why can't you take them out of order? And what do you intend to call them for what limited purpose? Give me a little proffer. I'll decide whether there's a legitimate interest in this that overrides Bryan Kohberger's right to a public trial to have his family there. Now, it is a public trial, and they're not excluding his family members just because they want to. There is a legitimate purpose. The question is it going to rise to the level where the judge will exclude them, or if some other reasonable accommodation can be met. Now, the state can say, hey, judge, we have a certain presentation of evidence. We think it's imperative that we call it in this particular order, and to take it out of order, frankly, would not only prejudice the prosecution's case, but it may also prejudice Mr. Kohberger's case as well. Something to think about. So we'll look forward to that. And then motion to seal defendant's trial brief. The defendant's trial brief is going to be sealed. Motion to seal defendant's proposed jury instructions. Now, this one I really just don't understand, ladies and gentlemen. Jury instructions are jury instructions. Most of them come from a standard jury instruction book, right? For example, here's Colorado jury instructions. It gives the jury instructions for every offense. Every definition. They have people, judges mostly, that volunteer to write this stuff. Very, very boring stuff, but very, very important. I'm not sure what the big secret is. Now, the defense never has to tender any instructions until the case is over. So I understand that, I guess. But if it's general principles of law, what's the big deal as to what they are proposing, right? General denial, probably include an alibi instruction. I mean, a lot of this stuff, it depends on how the evidence is presented. You may think I have got a great alibi instruction or a great self-defense type instruction, but if the evidence doesn't come in, a mere scintilla of evidence has to be presented for the jury instruction to be presented, then what's the big deal? No big secret, right? Everybody knows what the defense is going to be. Well, he wasn't there. It wasn't him. You can't prove it was his identity. We'll talk about that more in a minute. But the reality of it is, I don't understand what the big secret is. Now, the defense can always submit a theory of the case instruction. I'm not a big theory of the case instruction, which is basically says, hey, ladies and gentlemen, here's our argument. If you can't figure it out by now, I've failed as a defense attorney. Okay. And you don't have to submit that until the case is basically done. Everybody's rested. Judge will say, would you like a theory of the case? No, Your Honor. If they don't know that this is, for example, a self-defense case by now, I have failed miserably because I'm going to tell it again in closing argument. So I'm not sure why that is such a big deal. Motion to seal, defendant's response to State's Exhibit S1 to State's first State's supplemental discovery. Blah, 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 right? I just don't get it. These will more than likely be released rather quickly. Motion to seal exhibits to the defendant's fifth supplemental discovery response. Order, sealing defendant's proposed jury instruction. Order, sealing defendant's response to State's Exhibit S1 to State's first supplemental request for discovery. And order, sealing defendant's trial brief. Now, a trial brief, ladies and gentlemen, well, that's usually for trial, right? You can brief lots of things, but sometimes, not so much in criminal cases, but more in a civil case, you can submit a trial brief. All right. If you think an issue is going to come up and maybe the court hasn't ruled on it and it's going to wait and see how the evidentiary things play out, then you can say, but Judge, I have a trial brief for you. And normally those are resolved. I'm not exactly sure what they want to put in their trial brief in this particular case, other than throw out the death penalty. Okay. Let's talk about that some more. All right. Now, one more thing I want to talk about as it relates to the Bryan Kohberger matter is the amount of briefing that has been done in the Kohberger case on this whole autism spectrum disorder. Now, obviously, Kohberger is accused of 4 brutal murders and the burglary charge, and the defense has filed numerous motions about his autism. And let's face it, ladies and gentlemen, when you start talking about something that is mitigation that much, and I understand there's a place for it, but you kind of get the feeling as though they're really saying, hey, have we mentioned he has autism? Hey, have you mentioned he has autism? You should probably take that death penalty off the table. Have we mentioned he has autism? And that's kind of the way it feels. All right. I thought the motions hearing didn't go well for the defense in this particular case. Now, some people disagreed. Some people said, are you kidding me? My God, they crushed it. It went wonderful. I'm like, okay, if that's how you saw it, good to go. I'm telling you, from a defense attorney's perspective, they didn't get a whole lot of anything out of that hearing. Their arguments weren't, very persuasive to the judge, at least from what we could tell. We'll wait for the written orders, but it didn't look like he was buying what they were selling. So let's get realistic, ladies and gentlemen. One thing I'd like to pride ourselves on is we just call it the way it is. I don't have a dog in this fight for Bryan Kohberger or against Bryan Kohberger. I don't know. We'll have to wait and see if the prosecution can prove their case. I believe he's entitled to the presumption of innocence, but I'm also not an idiot either. All right, let's face it. The evidence against Kohberger is starting to stack up. Obviously, we got the whole DNA on the knife sheath found at the time of the crime scene, right? Matching a swab taken from him after his arrest. That's obviously a big part of the prosecution's case. Now, obviously, his defense claims an unknown perpetrator must have brought the sheath into the house. And let's face it, that's starting to feel a little implausible because, frankly, we've had 2.5 years since the murder. And if there was an alternate suspect, and I assure you, if the defense had a viable alternate suspect, they would have let the court know by now in their pleadings, as well as the world to know that this is the alternate suspect. But they haven't because they don't have one. And that's just the way it is, okay? And I'm telling you, done defense for criminal defense for 30 years, ladies and gentlemen. If they had it, they would be shouting it from the mountaintops that they had a third-party alternate suspect. So let's just get realistic there. Then the defense wants to highlight various gaps, like the lack of direct evidence tying Kohberger to the act itself, or the presence of some other DNA at the scene. But once again, no viable alternate suspects. So they're leaning hard on this whole autism diagnosis. They filed numerous motions backed up by expert testimony, neurologists, you name it, arguing that his condition makes the death penalty cruel and unusual and should be in violation of the 8th Amendment to the United States Constitution. So the claim his autism impairs him emotionally and cognitively, and his capacity basically renders him less culpable. Like I said, that is mitigation. However, Judge Hippler shown little patience for these arguments, dismissing them rather quickly when they were argued at the motions hearing. So the defense pretty much gets it, that they're not being very successful in persuading the judge that they should take the death penalty off the table in this particular case because of this autism spectrum disorder. The judge has alluded to the fact that this guy was working on his PhD, right, at a pretty distinguished university, and apparently, according to his attorneys, has a 119 IQ. And professors have said when he was working on his master's program at DeSalle University, where he was described as one of the top students in 10 years of teaching that professor had been teaching and had come in contact with, and then try to sit there and argue that this person is mentally impaired. Yeah, it kind of flies in, what people see in court. As remember, they made the argument that they want to be able to talk about his condition in front of the jury. But yet we see in court that he's not fidgeting. He's not doing anything that would make somebody feel uncomfortable that needs to be addressed. So they keep trying to say, well, maybe he's been uncooperative and it's hard for him to make decisions and to really understand the charges. Do you really believe that he doesn't understand the charges? And somehow they describe him as so recalcitrant that he is unable to provide or assist in providing an alibi. Well, I would say if he is that bad, if he cannot assist in his defense, then his attorney should file a motion to have him comped. That's right, to see if he's competent to stand trial. Because one of the things to be able to be competent is to obviously understand the proceedings, the nature of the charges against you and the consequences and how things handle in court. But you also need to be able to assist in your own defense. And if you're unwilling to do that because, you don't want to, that's one thing. But if you can't do it because you have some sort of mental impairment, then he should be comped. But I would guess these experienced veteran attorneys would say, we have competency issues 2.5 years ago if they thought that were the case. I think is a little bit of a disingenuous argument that's being made as it relates to Kohberger's autism, that somehow says that he can't make rational choices. Like, does he accept a plea deal to save his life? Are there family members that are pressuring him? Something along those lines. So, but that's not a reason to take the death penalty off the table. Just because you are stubborn is not a reason to remove the death penalty. My guess is, and I say guess because I do not know, I say it's speculation, and we usually don't try to speculate, but I get the feeling, felt like the winds were knocked out of the sails of the defense attorneys for Kohberger this last hearing. They know the evidence is stacking up. Their goal is, as capital defense attorneys, is to avoid the death penalty. And like I said, speculation, rumors. I read some things saying that, that there's possibly been the option for, taking death for a guilty plea. But some other people are saying, don't do that to Kohberger. We'll have to see if that, in fact, bears true. I just get the feeling. So anyway, I think the case for innocence in the Kohberger matter is looking about as clear as the stars on that fateful night back in November of 2022, as well as all the DNA evidence and the lack of viable alternative suspects. Something has to give. And the autism mitigation argument is, something that the defense is working on. And it's a change from their client's innocence. As you may recall, Ms. Taylor always said, he's innocent. I believe he's innocent. You're not hearing that so much in court anymore. Anyway, will his diagnosis be enough to save his life? Ultimately, it may be up to a jury. Next on the docket, the Lori Vallow matter. That's right, day 8 in the Lori Vallow trial there in Arizona. And guess what? The prosecution has rested, and Miss Vallow has said that she would rest her case as well without calling any witnesses. Now, Vallow didn't announce her decision in front of a jury as of yet. She spoke with her advisory counsel for a few minutes. And while she has not called any witnesses to stand, there is a chance that she could change her mind between now and Monday and decide to testify in her own defense or call witnesses. However, I think that's unlikely given her statement where she says that she does not believe that the prosecution has proven her case. And officers were also released from her subpoena at the request of the prosecution as well. So it's over. And like I said, she's made the decision to rest her case, and the jury will appear on Monday. They will have the judge read them the jury instructions. Then both sides will then begin to argue for both sides. Obviously, the prosecution is going to claim that they have proven their case beyond a reasonable doubt to each and every element of the offenses charged, and that they should find Miss Vallow guilty. Obviously, Lori Vallow, without testifying, will have to go up there and make an argument for reasonable doubt, saying that there is no proof that there was a conspiracy and that the murder of her husband, Charles Vallow, was in self-defense. You know, we're just going to have to wait and see. We'll have to wait and see. Anyway, next Monday, the jury will be present and they will hear the arguments. After Lori Vallow is asked in front of the jury, does the defense intend to call any witnesses? Lori Vallow is anticipated to say, the defense rests. Next, the Karen Reed case. One thing I don't think I can recall anytime in the recent past is that we have Karen Reed out there giving pre- and post-court interviews. Literally, it reminds me of athletes being asked, how do you think the game's going to go today? She was asked one of these questions, and she basically said, well, I think it's really going to go well. I've got a great team. We believe things are really going to go well. Let's go in there for the big win, right? It reminds me of a sporting event, and I cannot recall the time where we had, like I said, a defendant who didn't testify in the first trial that resulted in a mistrial, appearing on documentaries, and now the prosecution is going to use the statements against her from those documentaries. And when I watched them, I was like, ooh, I can't believe she said that. So it's interesting, ladies and gentlemen. I'm telling you, as a defense attorney, deep in my heart, I know you want to go tell your side of the story to the world. Save it for court. And yes, I've said it before and I will say it again. When you go into court, there are two types of people, those that are humble and those that are about to be. And I'm telling you, Miss Reed, you don't know me. You have to follow my advice, but you need to go into that courtroom and you be humble. You let your attorneys take care of things, but you need to shut your mouth, stop talking to the press, because every time you open your mouth, I swear, I just like you a little less and I'm kind of rooting for you. Okay? We'll see if the prosecution can prove their case, but there's just something about Karen Reed that is just so damn annoying. The less I hear from her, the more likely I will probably think that, the prosecution hasn't proven her case. But every time she opens her mouth, and I don't know what it is, I just become, I just don't like her. Anyway, I probably shouldn't have said that, but that's the truth. Anyway, the judge overseeing Karen Reed's case is going to allow a dog bite expert hired by Karen Reed's defense to testify at her second trial, and blocked the testimony from an expert hired by the prosecution in a series of orders that were issued late last night. First, former police lieutenant Garrett Wing will be allowed to testify that injuries sustained by Karen Reed's boyfriend, John O'Keefe, were consistent with a dog attack. And the judge found that Wing appears to be qualified by experience to provide some help to the jury on the issue that is in dispute. But in a bit of a blow for the prosecution, the judge blocked their expert, James Crosby, from testifying O'Keefe's injuries could not have come from the German Shepherd that Reed's defense has said caused caused the wounds. Reed's lawyers have claimed that the German Shepherd named Chloe attacked O'Keefe inside the Canton home of their fellow Boston police officer on the night that he died. And the judge set a Friday deadline for Karen Reed's defense to turn over additional disclosures about the crash reconstruction firm that is central to her defense as she faces a retrial for murder, obviously, that we are going to have start on Tuesday after the Patriots Day holiday, which is apparently a big holiday in the New England area. I'd never heard of it, but I like it. Patriots Day. I love it. Anyway, prosecution wants more stuff turned over as it relates to the ARCA. The ARCA witnesses have been a key issue ahead of Reed's second trial, with the prosecutor, Mr. Brennan, having asked the court to have their testimony precluded over concerns that they were not independent as described and had been contracted by the defense without disclosing their financial ties. That motion was denied. Next on the docket, this day in legal history. On April 17th, 1924, the Johnson-Reed Act, it restricts immigration. It's debated in Congress, setting the legal quotas that shaped the United States immigration laws for decades. On this day in 1935, the FBI intensifies its pursuit of John Dillinger's gang, leading to a shootout and legal reforms strengthening federal criminal crime-fighting powers. On this date, April 17th, 1942, the United States Supreme Court hears Quirin v. United States, later upholding military tribunals for enemy saboteurs, shaping wartime legal precedents. On April 17th, 1969, Sirhan Sirhan was convicted of assassinating Senator Robert F. Kennedy and was ultimately sentenced to death. The sentence was later commuted to life in prison after the Supreme Court in California overturned the death penalty in that state. Then the voters brought it back. On this date in 1986, the Anti-Drug Abuse Act is debated, later signed, imposing harsh penalties for crack cocaine, shaping modern drug sentencing laws. That's right. Former President Biden, Senator Biden, he was a big purveyor of that. So if you had 10 grams of crack cocaine, you were sentenced as though you had a kilo of powder cocaine. Some would say that that was racial, prejudicial, because the epidemic was primarily in black communities at the time. And then on this date in 1993, April 17th, the Branch Davidian siege in Waco, Texas ends in a deadly fire, leading to legal reforms in federal law enforcement tactics. Lots of good documentaries about that. It was a big mess on both sides. Both sides were at fault on that one. And then finally today, our dumb criminal of the day. Take a look at this video. This girl thought she was going to be cute. She thought she was going to be funny. Take a look at it. She climbs into the back of a police car thinking it's funny. Turns out the only ride that she was going to get was not to the bar where she thought the cop was going to take her. Apparently she thought the cop was an Uber or something.
I'm of age. Are you kidding me? I'm sorry. Oh my God. Get out of it. No! Close the door. Both of you get over here now. Both of you get over here right now. Give me your IDs. What in your mind would make you think that you should get into the back of a cop car?
I'm sorry.
Give me your ID now.
Okay. Okay, I'm sorry. Ma'am, I'm sorry.
Give me your ID.
I'm sorry. Ma'am, I'm seriously, I'm sorry. I didn't mean to. It's a senior bar call. I didn't mean to.
What in your mind makes you think that you should get into a cop car?
Because we wanted to ride to the next bar.
Do I look like a taxi?
No, you don't. I'm sorry. Seriously, I didn't know it was going to be like this. I'm sorry.
Okay. Go ahead and hand me your purse.
Absolutely.
Go ahead and turn around and face the car. Put your hands up on the side of the car. I sure am. Put your hands up on the car.
Anyway, no, she got taken to a ride to the police station. Unidentified college student, you are our dumb criminal of the day. Congratulations, you made it. Somehow I think you will never, ever do that again. Thanks for watching. We'll see you next time. Have a wonderful day. And remember, the Constitution matters.